Hi, my name is Amber Solana, and for my research project, I chose to do my work on choreographic copyrights, specifically the case of Fuller versus Bemis. For my thesis, I wrote how and why did Louis Fuller's choreography ownership court case, Fuller versus Bemis, during the late 1800s affect the future of whether dance choreography should be patented or not. For a basic general background about Louis Fuller. So, Marie Louise Fuller was born on January 15th, 1862, in Hinsdale, Illinois, and she died on January 1st, in 1928, in Paris, France. She made her first debut on stage when she was just 4 years old, and she spent the next 4 decades performing in burlesque shows, vaudeville, and Buffalo Bill's Wild West shows. However, she became an international sensation and she became known as a pioneer of modern dance because of her innovations in theatrical lighting, as well as her invention of the serpentine dance. The future of modernism was shaped through her ideas in dance, stagecraft, music, and scenic design. She was also the inventor of the first chemical mixes for gels and the first use of luminescent salts to create lighting effects. The dance that she became most well known for, and the dance that put her name on the map, was her serpentine dance. And the definition of serpentine in the verb form is to move or lie in the winding path or line. As shown in the picture on the left, you can tell in the long skirt that it's moving in a winding path, which makes her work original, and that is what describes her dance movement. And this dance is known for its distinctive use of yards of illuminated China silk fabric. And this is basically a skirt dance with a burlesque influence, which she got from her background in burlesque dancing. And her costume consisted of 100 yards of silk, and she would pull up the waist of the skirt just underneath her breast, creating an empire waist gown. And she danced beneath a dazzling array of multi-hued electric lights, which set the material aflame with color, as also shown in the picture to the left with the blue color illuminating. Her onstage persona mesmerized audiences, and she became an overnight sensation in Paris in 1892. And she was one of the first famous dancers to become famous in Paris from the US. And audiences depicted her as a fairy of light and illusion. So the picture on the left is a first-hand photo with her work with the skirt, and the video on the right is her serpentine dance, and I will show a small clip of it. Now we'll dive into the case of Fuller versus Bemis. In 1892, Fuller was attempting to sue Bemis for copyright infringement of her serpentine dance. And at the time, there were many imitations of her work, so she wanted to get justice and get her dance copyrighted. She was seeking an injunction specifically, and an injunction is when a court requires a person to cease doing a specific action, and in this case, to cease her performing the serpentine dance. And this injunction was set against Minnie Renwood Bemis. And in the law, this was a case of equity, which is a type of civil law, which means that the person was basically fighting for a positive remedy in this situation compared to criminal law, which is when they want the other person to have a punishment. And this case took place in June of 1892 at the U.S. Circuit Court in the Southern District of New York. A basic background of why this case came to be was Bemis was currently working as a professional dancer under a contract with Madison Square Garden in New York City, and it stated that she had to perform in the long skirt. Prior to this, Louis Fuller also had performed on the same stage in Madison Square Garden. Bemis claimed that this dancing with the long skirt was not original, but Fuller claimed that this was a nature of copyright as a branch of intellectual property law. In order to support each of their claims, Fuller's main witness was her mother, and Bemis's main witnesses were teachers and actors who saw the performances at Madison Square Garden firsthand, so they could see that the dance with the long skirt was not an original thing, even though dancing with short ballet skirts were the most common at the time. And at the end of the case, the affidavit which also means case verdict, was to oppose motion for injunction, which basically means that Louis Fuller lost her case. The judge for the U.S. Circuit Court denied Fuller's request for an injunction on the grounds that the Serpentine dance told no story and was therefore not eligible for copyright protection. The judge said that it is essential to such a choreographic composition that it should tell some story. And even though Fuller clearly regarded her expressive output as intellectual property, dance at the time lacked legal recognition as copyrightable category and was merited protection only if it qualified as a dramatic composition or a dramatical musical composition. So even though she stated her claim that it was intellectual property, because it didn't tell a story, it was denied, even though that's not what she was claiming. And also, even with that claim, the U.S. courts did not see choreography as a copyrighted case at the time. And at the time, dance wasn't protected under the 1870 Copyright Act, similar to what I just stated. But in this photo, in 1894, just 2 years after this court case, Louis Fuller actually did get the actual garment for dancers patented, so she did have some success with that. In the top, it shows the skirts and the pulls under, and that she uses the flow skirts with. And in the bottom photo is her doing the silk work. So she did get one thing successfully copyrighted. And so the question is now, how did this court case affect the future of choreographic copyrights? So the precedent set up by Fuller versus Bemis remained in place in the U.S. until the 1976 federal copyright law, which explicitly extended protection to choreographic works, and is now among the categories of works that may be protected under the U.S. Copyright Act as stated in Section 102A4. However, there is a set of criteria that need to be met in order for choreography to be copyrighted and for it to just technically be called choreography. So the components are number 1, rhythmic movement of one or more dancers' bodies in a defined sequence in a defined space. Number 2, a series of movements organized into an expressive compositional whole. Number 3, a story, theme, or abstract conveyed. Number 4, a presentation before an audience. Number 5, skilled individuals in the performance. And 6, a musical or textual accompaniment. So many people believe that choreography should be copyrighted, but it has to have a certain set of components for it to actually count. So if you tried to copyright a TikTok dance, that wouldn't work because there are many components. It doesn't mean everyone would agree with that. And also, Louis Fuller would probably still not get the copyright at this time because even though the skirt played with many of these components, it still didn't have a true story. So, but in the picture shown on the bottom right, it's a dancer, Letty Lind, playing with the long skirt, showing a story of going, going, gone, and the way that she played with the skirt to create a little story could now play into the 6 components needed to get copyrighted. So, if Louis Fuller worked with creating the story with the dance, she would have been successful, most likely. And that is my presentation on choreographic copyrights within the case of Fuller versus Bemis. So thank you for listening, and here is my works cited page.